Hi, my name's Christopher Burgon. I own and run Christopher Burgon Solicitors. We are specialist litigation and commercial solicitors based in London. One of the big problems that my clients face is if they're in a company and the company has two people in it, both of them are directors and both of them are 50% shareholders. Now, why is this a problem? The basic reason is that it means that nobody has any power in the company if there's any kind of disagreement. Because you're both directors, if you set the company up with the model articles of association, that means that decisions on behalf of the company can only be taken either with a majority or a unanimous vote of the directors. So if you don't agree, the company can't move forwards. If you're 50% shareholders, that means that neither of you has the power to take control of the company, either by overruling the directors, where you need 75% of the shares, or by dismissing one of the directors, where you need 51% of the shares. So there you are, you're in a company and you're stuck. And that means that people start breaking the law, acting unlawfully, acting outside their responsibilities as directors, bringing the company down. So that basically the company goes into a deadlock, everybody falls out, and business suffers. We're going to try and give you some solutions to avoiding this deadlock situation, and if it occurs, how best to deal with it. So we are litigation solicitors, that's what we specialise in, but we are also commercial solicitors, and we believe in prevention as well as cure when it comes to business disputes, particularly amongst directors and shareholders. So taking that prevention is better than cure mantra, we would say the best thing to do is to prevent a 50-50 deadlock by setting up a proper company constitution so that you avoid the scenario altogether. Now, the easiest way to do that is for you to agree when you go into business that ultimately one of you is going to be in charge. Now, you can do that by giving one of you 51% of the shares and the other 49%, or you can both have 50% shares, but in board meetings one of you can be given the casting vote. You can even alternate the casting vote, so someone can run the company for 3 months, someone can run the company for the following 3 months. If you don't fancy doing that, if really you can't decide between you who's actually going to be in charge, then what you need to do is put together a shareholders agreement that's going to include some kind of dispute resolution procedure. Now, the simplest dispute resolution procedure is to outsource it. Say, okay, in the event that we fall out, that we can't agree, that we come to a deadlock, then somebody else, a third party, will be appointed and we will abide by the decision of that third party in relation to whatever the issue is. Now, you might want to nominate somebody that you both know and trust, or you might want to put in a procedure where somebody that you both can trust is put into place, such as a surveyor or an executive director or a lawyer or an accountant, somebody like that. The other thing to do is that you could perhaps divide up the company. You could say, okay, when it comes to marketing, sales and accounts, one person can have the final say. When it comes to operations and property matters, the other person has to say. Again, that's a way of just dividing up the responsibilities in the company so that you avoid that deadlock situation. If you want to get into more complex ideas, in a shareholder agreement you can have various provisions whereby if you've really fallen out and there's no way through it, you can put in place procedures where one of you can buy out the other. So you need to agree in advance that these procedures will be binding, but what it means is that if you come to a deadlock, you can say, okay, I'm going to now rely on this procedure. I'm going to buy your shares or you're going to sell my shares. It takes a big leap of faith to put this in a shareholders agreement, but they can be very useful, and it stops the terrible deadlock situation where you're stuck in a company that's really not working well and where one of you is having to act unlawfully to keep the business afloat, or one of you is actually undermining the company. So what are these share sale procedures? Well, they have great names. The two that come to mind are the Russian roulette procedure and the Texas shoot-up procedure. In the Russian roulette procedure, one person serves a notice on the other. They put a price on the shares and they say, okay, you can either sell your shares to me at this price, or you can either buy my shares at this price. If you get no response, it's up to the person that sent the notice to decide whether they buy or sell. If you serve a counter notice, you can say, okay, I'm either going to buy or I'm either going to sell. So it's an agreed procedure, stops the deadlock, means that one of you is going to own the company and the other is going to walk away with a price for their shares that hopefully they're happy with. The other is a Texas shootout procedure. In a Texas shootout procedure, both parties put in a notice and it's either to buy or sell the shares at a certain price. Now, if both parties' notices want to buy, then the one that put the highest price in gets to buy the shares. If one says buy, one says sell, then that's fine. That transaction takes place. If both parties' notices say that they want to sell, then it's agreed that the company will be put into liquidation, a members' voluntary liquidation, which means that the company will be wound up and any excess assets will be split. There you go, prevention is better than cure. Avoid deadlock by working out different responsibilities between the parties. If you can't agree that one person is ultimately going to be in charge, get a shareholders agreement where you put in dispute resolution clauses, or you put in clauses such as the Russian roulette or the Texas shootout procedure, which means that in the event of a deadlock, you can come to an agreeable share sale.